All right, guys, we continue on with Unit 3. We're going to cover 3.9 today. I will say this is pre-recorded, not from Denville, but from your school here. This is due process and the right to privacy. So I'm going to go through this a little bit quicker than the earlier sections of this unit. Hopefully you don't mind. I'm sure you don't. And we can go over some of these ideas and concepts more thoroughly in class. Now, there's a few reasons why the 14th Amendment is sort of considered the second founding, because it allowed for a different way to look at the Constitution, some say, or in the way it extended the rights of certain things through states. So we're talking about due process. We can also talk about equal protection. Keep in mind that they're not the same things. And even with due process, there's different types of due process. We have procedural due process and we have substantive due process. So with procedural due process, think of the procedures involved with laws and how they affect individuals. The government must take fair steps to protect certain rights. They must have a fair procedure before taking liberties away. If you're going to lose your rights to bear arms, for example, there must be a proper trial in case that shows that why that's going to happen. Not separate for that, but part is that. And so you need to make sure all certain steps happen, that you have a fair trial, that you have a right to an attorney, and all those things. Then there's also substantive due process. And that must mean that in the first place, the substance of the laws need to be clear and fair. And this counts for all liberties that are both listed and unlisted. All right, so then you see the bottom of the 14th Amendment, it says the jurisdiction, the equal protection of the laws, so that everyone must have equal protection, regardless of, what state you're from, your race, your gender. What about things like age? For example, the government may not discriminate based on all these types of factors unless there's a rational basis test. For example, it's reasonable to goal to prevent underage drinking and prevent the harm that can come from that, or the driving while intoxicated accidents and deaths, all those sorts of things. Okay, so then we have also scrutiny of the laws. There's independent scrutiny and there's strict scrutiny. So independent scrutiny is often looked at in times of gender. If there is a gender discriminatory law, it must make sense and it must be part of the government interest. So I'll show you an example of one that was changed. Used to be that women could not go to VMI, Virginia Military Academy, until very recently in the 90s. Say the military academy, that wasn't the case. Women could not go until the 70s. And hell, when I was there, you still heard people that voiced their opinions that didn't think so. Well, I was there. The courts had the laws and changed so that women had to be allowed to go in Virginia. And I have some stories about that if you were mind to ask me. Now, what about strict scrutiny? That can be seen sometimes often in case of race. So, for example, the Supreme Court changed a law because of Loving versus Virginia. I believe this was 1967. And Virginia, the law was that people of different races could not intermarry. And the Supreme Court said states can't pass laws like that. It violates the Equal Protection Clause. It's crazy to think, guys. 1967 is not that long ago that these kind of laws still existed. All right, and another example, which we'll go over more in class because this is one of our required cases, is Roe v. Wade of 1973. And some background is that here, Texas banned all abortions, and we'll look at this. There's several people that contested that. The precedent in this case was Griswold. If you go to the right, Griswold versus Connecticut was in 1965. And in Griswold, it was actually a Connecticut law that banned drugs or measures or advice that prevents conception. So no like contraception. Um, Doctors could not even help their patients with this. So two people from Planned Parenthood got advice. They were a married couple and they were arrested. And the holding was that this violated the 14th Amendment due to the due process clause and the right of privacy. This then it was in effect a precedent for Roe v. Wade. So as you look at some of the state cases going on now, they look at Roe v. Wade as a precedent. Well, Roe v. Wade looked at Griswold versus Connecticut as a precedent. So the effect on Roe v. Wade was that overturning these laws, it did award women more economic and social equality, but it also intensified the political divide and debate concerning it. And it also impacted a lot of elections, whether a candidate supported or opposed, whether they were pro-life or pro-choice or the other terms that are thrown around, is a big part of elections now. And also SCOTUS nominations. You may have seen that, and you'll see this when we see the new justice soon. The candidate get vetted. You'll see the senators ask them about this because this is going to be a big issue. All right, so these bans on abortion then became unconstitutional for a few reasons. They believed that it was a decision that an individual made with their doctor in privacy, so it cannot violate the privacy laws. And remember, there's several ways privacy is interpreted or seen in the Bill of Rights. It also helped increase the laws in regarding to female privacy and their bodily integrity. However, this right is not completely absolute. The government is able to look at other interests of the state to protect the life of the fetus. So right now, that's looks at viability. So when the fetus is considered viable, then they have a compelling interest as well. And right now with medical science, the age of viability may be shifting to a younger amount of weeks of gestation, which is something you'll see through these debates as well. So like I said, we'll get into this more. And you want to look at how these cases look at popular sovereignty, right? How they bring the idea of people's rights and opinions and all sorts of things that we'll discuss out of the Constitution. So according to the AP folks, they say this includes the opening phrase, we the people. You've heard me beat to the ground that it's really we the people of the United States, and it's a federalist statement and not a warm and fuzzy we the people's rights statement. But you do see that in other places, which was important to the Anti-Federalists. You see it in the Ninth Amendment, right, that these rights cannot that they are retained by the people, and the 10th Amendment that other powers are reserved to the states, respectively, or to the people. So you definitely see it there as well. All right, so I said I'd keep this shorter, so I want to stay true to my word, but of course we'll go over this more in class. All right, bye guys.